Bond, Ms. Thomas, is there a reason why you can't sit up and take your whole, so we could just see your whole face? Is there a reason why you can't do that? I can't hear you, you're muted, but it's very distracting. It's very distracting when you put your whole face and eyes up to the camera. If you could please sit up straight for me. Can you unmute and tell me why you can't sit up straight? Because this is
should I stand up? This is my first time, so I don't know how to work it. So am I doing correct now?
No, ma'am, you're sitting right up to the can you, I mean, do you see how the rest of us are sitting up straight? Do you see how we're sitting up straight and you can see half of our upper body?
Can you see me now?
Yes, ma'am.
I had to stand. I don't know how to work this.
Ms. Thomas indicated she'll be coming in person in the future.
She should come in person because she keeps saying, she keep owning that she don't know how to work it. It's nothing to work. It's easy. It's just, you just put the device down and you just stand in front of the camera. Nonetheless, okay, ma'am, ma'am, I need you to stabilize your device. Okay, let's hurry up. Let's hurry up. Number one, she keeps talking. That's number one. She keep talking. Number two, she's back right up on it. But let's just move. Let's go. Let's go. Okay.
All right, let's go back on the record.
But let me make something clear to you today.
Prosecutor's office.
What do you want to give me?
Jolie
Fear of you.
Possession of a shopping cart. Oh my God.
Is that a serious charge, you think? Is that a serious charge?
Heinous. Heinous.
I was muted the whole time. All right, let me try again. Y'all didn't see me talking and say, Judge, you muted. Because y'all don't be paying attention. Look up when it's time for the cases.
Yes, Your Honor.
This is case number 2245-06701, the People versus Antonio Terrell Thomas. Defendant is charged with one count of movement violation causing death. Today is the date set for review and restitution hearing. The restitution hearing part did not appear on the docket. I needed to be reflective in the register of action, though. Appearances, please.
Good afternoon, Your Honor. Christina Ritter on behalf of the people, P number 83505. I also have the deceased complainant witness's wife present via Zoom this afternoon. Ms. Golden, can you state your appearance on the record, please? I'm sorry, unmute Ms. Golden, state your name.
Crystal Golden.
And for the record, and for the record, Your Honor, Janice Stevenson appearing on behalf of Antonio Thomas. Mr. Thomas, sir, please tell the judge your full name.
Antonio Thomas.
Mr. Thomas, what's your middle name, sir?
Terrell. I'm sorry, Antonio Terrell Thomas.
That's okay. Today is the day set for review and restitution hearing, probably more so just the restitution hearing, because when did I put Mr. Thomas on probation?
March 15th, I think, Your Honor, of this year.
Did I send you something on him from probation?
I think you did.
Oh, okay. Well, hold on.
Yes, you did.
Oh, okay. Oh, I did. So according to Mr. Hunter, basically he's just been reporting to probation, and then he still has to pay his fines, costs, and fees. He was referred to affordable testing. He has 15 days of community service. And he's already completed the mental health evaluation, but he needs to forward it to probation. So basically, he's just at the beginning of probation, so we could just go ahead to the restitution hearing. With respect to the restitution hearing, so I'm going to continue him to another date, though. I have to give him another date for his next review. But with respect to the restitution hearing, Ms. Ritter, what are the people claiming? Are the people claiming restitution, and if so, what are the people claiming?
So, Judge, I believe the last time we were here at sentencing, the court did want the people to verify if there were any medical expenses that were covered by medical insurance. But I did have an opportunity to speak with Ms. Golden regarding the funeral and burial expenses related to this matter. And I did submit a copy of the funeral bill to sister counsel in the court. So the total amount for the funeral expenses was $4,330.94. I have received an update from Mrs. Golden's civil attorney, who did indicate that there was, I'm sorry, Judge, I'm just pulling it up. There was a claim made with the Michigan Assigned Claims Plan, and they are paying $1,750 towards the funeral and burial expenses. So
that would leave a balance of what? I didn't write the numbers down. I apologize. Well, I saw the email. I saw the funeral bill for
$330.94.
Yes, so I saw that, but then I didn't hear you say how much did they say that they would pay?
$1,750.
Even?
Yes, Judge.
Okay. So according to my calculation, that would then leave $2,580.94.
That's the amount that I have, Judge. And that's the amount that the people are requested in restitution in this matter. Again, I spoke with Ms. Golden regarding this case. As far as the medical expenses, from my understanding, Mrs. Golden's civil attorney told me that those will be covered as far as the medical bills. So that just leaves us with this balance, Your Honor.
All right, Ms. Stevenson, on behalf of Mr. Thomas.
Your Honor, I'm going to ask that this matter be left to civil litigation. And
well, I'm just going to tell you, I don't have the option to do that. Under the Crime Victims' Rights Act, the victim has a right to restitution, even though they have a civil remedy. So I'm going to tell you, I'm going to order restitution.
Okay, if I could just be heard, Your Honor, I hear what the court's saying. And first of all, I want to say that Mr. Thomas remains completely remorseful. He didn't even know that Mr. Golden passed away until I told him that. I thought that, and that was in preparation for one of our hearings. And I remember, because it was really traumatic for me, I remember Mr. Thomas's response to receiving that information. He broke down and cried. And I have been working with Mr. Thomas. I think I did his arraignment, Your Honor, and I've been working with him on this case since its inception. And I'm gonna have to say that I have not seen Mr. Thomas smile until this court just made the little joke it made about us not knowing that you were talking. And I think that that's attributable to the fact that Mr. Thomas has gotten some counseling. He is in counseling right now. And I think that that's helping him to process all of the emotions that he's experiencing in this situation so that he can move forward from it. He's very sorry about this situation. but he did offer the court a no contest plea, and just we had some trouble with the whole case because in reviewing the matter, you know, unfortunately, and I'm so sorry for Mrs. Golden's loss, but her husband was riding an ATV vehicle on the public street, Your Honor, at night. And the police report even indicates that he ran into Mr. Thomas. And if Mr. Thomas's license hadn't been suspended and he was just in the process of taking care of that, I just don't even think we would be here today. So Mr. Thomas has never failed to accept responsibility for his part in this, but you know, this is a tragic situation. It's just a tragic situation. And if he had taken care of his license, I just don't even think we would be here today. So he's very sorry. I'm very sorry for Ms. Golden's loss, for her family's loss. But it was Mr. Thomas is not the proximate cause of Mr. Golden's death. So I do understand the people's position. I understand the court's position. I understand the reading of the Crime Victims Witness Act. But again, I just make that record that it would be our request that this matter be left to civil litigation.
All right, well, the court is going to order restitution in the amount of $2,580.94. Mr. Thomas, you have to make a good faith effort to pay that amount during the course of your probation. How long did I put him on probation for? I'm sorry.
It's 24 months, Your Honor.
But yeah, I think I put him on for 24 months, anticipating the restitution.
Yeah,
I think that's what I did. So you do have to make a good faith effort to pay the amount. If for some reason, it's on me. If for some reason, because I do understand that Ms. Golden does have a civil attorney who has in fact appeared on this court Zoom a few times. That might
He's
be
in
him.
the white room.
Right, he keep coming, but I don't know. Okay, you can let him in. And so they may, I don't know what the status of that case is, nor do I know if it gets resolved within the 2 years. So what I'm gonna say to you is that you do not have to duplicate payment. That's what I'm saying. If I ordered the restitution in this case, and then the civil case gets settled and there is an order of restitution, I'm sorry, and then this funeral expense is included in any judgment that is gotten against you, if that occurs, if a judgment, is entered against you, then the judgment being entered against you would be, you would get credit for that over here. I hope if I'm explaining that correctly. So what I'm saying to you is, because of the Crime Victims' Rights Act, she does have a right to restitution. I've ordered it. You have to make a good faith effort to pay it during the course of the 2 years that you're on probation. Once you complete any other terms of probation that I have ordered you to do, then I will discontinue your reporting. And you just have to make, good faith effort to make some payments on the restitution. So if you finish everything else I tell you to do, then I'm going to stop you from reporting, to probation and all those things, or whatever the case may be. And because Ms. Stevenson, I put him on a 2-year probation, but did I give him other conditions? I don't have it. Oh yes, hold on.
Community service.
Community service. So once you finish your community service and, whoops, wrong one. Let me pull up Mr. Hunter. Nope, wrong one still. Okay, hold on. So once you finish the community service, I did impose $860 supervision fee, but that's for the whole 2 years. If you complete the community service and and pay the fines, costs, and fees, not including, no, it looks like I only, oh no, if you complete community service and then pay, I can't do the math. It's like a little less than $7 or a little more than $700 and something, I think. Once I discontinue you from reporting, I won't charge you for the oversight fees. That's what I was trying to calculate. So do the community service and then don't get any new tickets, pay the money minus whatever outstanding months you have left on the probation. I'll stop you from reporting, and then all you have to do is pay towards the restitution. Okay. If you get to the end of the case and you have paid the restitution in full, but the civil case is still pending, just make sure that you keep record so that you can get credit. Like, again, I'm telling you, you don't have to double pay. If there's funeral expenses included in one order and in both orders, you don't have to pay for that twice. So you just have to make sure you keep your records if you end up paying the whole thing by the 24 months, okay?
Yes, ma'am.
If you pay it, or if you do pay it early, if you pay off the restitution earlier than the 2 years, but after 1 year, so you have to be on probation for 1 year. That's the halfway point. If you pay the restitution within that 1 year, then I'll completely close the case out and discharge you from probation. Okay?
Yes, sir.
All right. So that's the court's order. Let's make sure that the register is updated to reflect the $2,580.94. Anything? Oh, and I need to give him another date. So I'm just going to give you, let's see. I will have you come back to see me. Really at the halfway point. I don't think it's any reason for him to come and see me before the halfway point. Do you think it is, Ms. Stevenson?
Not at all, Your Honor. And I did have one request of the court.
Okay, go ahead.
So the court ordered 15 days of community service in this case. Yes.
I'll change it.
Thank you, Judge. And he's already finished 5 hours too, by the way.
So let's do this. If you complete half of that, let's see, 15 days. Oh, I said 15 days?
Yes, Your Honor.
Okay. Let me see what I'm going to reduce it to. That's 120 hours. 60. I'm gonna reduce it to 40 hours. 40 hours. I'm gonna reduce it to 40 hours. So if you do 40 hours of community service, if you pay the restitution and if you pay what was, let me see, total for the case was $1,700. Minus 4. So on this case, if you pay $1,270 plus the restitution of so if you pay $2,150 and 94 cents with it by the 12-month time, or at any point before the 24 months ends, well, I shouldn't say it like that, because the oversight fees are based upon how many months I have you reporting, but let's say if you report for the 12 months, if you pay $21.50 and complete the community service, then you'll be eligible to be discharged early from probation. Or if you provide proof that you've paid the funeral expenses from another forum, like if you just provide proof that you paid that as a part of another judgment or something, but after 12 months, I can discharge you from probation, okay?
Yes, ma'am.
All right, and then I do again want to also offer my sincere condolences to Ms. Golden, no matter what the circumstance, no matter what the situation, no matter even if our loved one was in the wrong, it's still the same, they're still deceased. And so therefore, you know, obviously, and I understand that Mr. Thomas is limited in what he can say because of the pending case, and this being a no contest plea, but we are very sorry for your loss, and we, you know, I hope that as the time goes by and the days get, you know, the days of the event are further behind, that you are able to manage easier your days, your regular days, get through them a little easier. My sister has been deceased now, I think, for 7 years. So at least from my perspective, it gets, you're better able to manage it, is what I'm saying. You don't get over it. Somebody's death, you never get over it. So that's what we, you know, hope for you. Okay, anything further?
Judge, there was one thing, but can I just have a real brief breakout room with defense counsel?
Real brief, because the court has
Very
to go.
brief.
Okay. We can go to number 1. I had put them in the waiting room because I didn't want.
Oh, okay.
Mhm. Okay, so then there's nothing else for the record then.
No, Judge, nothing from the people. Thank you.
All right.
Nothing on behalf of Mr. Thomas. Thank you, Your Honor.
All right, we're all set then. Everyone have a great day. Stay. So what? I'm sorry. What?
Were you giving a new court date or no? That was just it.
Oh no, I said his. I'm sorry. I thought I gave the date. I said after 1 year. So what would his halfway point be? When did I put him on probation?
March 15th, 2023.
And is March 15th, 2024 a weekday?
March. Yes, it's a Friday. You
Then
said
that's-
15.
Yeah, that's the date.
Thank
All
you,
right.
Your Honor.
You're welcome. Have a great day. Stay
I'm
safe.
sorry, is that 10 a.m. or is that 1:30?
It's 10 a.m. It's a Friday. You
Oh,
know
that's
that.
right. Yes.
I have to go. What?
Dumb question.
Your Honor,
Mr. Murphy?
if I may be allowed just a brief factual correction for the record, if the
No,
court
Mr.
will allow.
Murphy. No, I won't. I'm sorry. You have to let the prosecutor know.
That's fine. Thank you, Your Honor.
This is case number 2244-08501. The People versus DeQuinn Jamal Wallace. Defendant is charged with 1 count of assault or assault and battery. Today is the date set for an arraignment on a bench warrant. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson on behalf of Mr. DeQuinn Wallace. Mr. Wallace, sir, please say your full name.
I'm Jamal Wallace.
Today is a day set for an arraignment on a bench warrant. Mr. Wallace has habeas on at least 4 occasions from his pretrial conference. How are we proceeding? I didn't hear you.
He stands mute. He waives the reading of the information. We ask that a plea of not guilty enter on Mr. Wallace's behalf.
Court will enter a not guilty plea on behalf of Mr. Wallace. I mean, I usually say and set the matter for pretrial. And I will set the matter for pretrial, but we're definitely going to address bond today.
Understood, Your Honor.
Set the matter for pretrial conference.
Your Honor, I was at a.
No, sir. No, sir. Please don't do that. Don't interrupt my court like that. No, sir. Court is going to set the matter for pretrial conference. Ms. Ritter, on any of those previous occasions, was discovery submitted? You're muted.
I don't have notes that the discovery was submitted, Your Honor.
Mr. Flanagan, well, let's just set the pretrial conference for April 4th at 1:34. Ask the bond, well, before I address bond, I'm going back on the record. Okay, back to Mr. Wallace. Ms. Stevenson asked to bond. Did he post a bond to get this particular court date?
So I believe, I'm double checking right now because I know previously there was a tether that was ordered and I just don't see whether it's still on. So I'm gonna check right now. And it looks like there was a bond redetermination.
What date are you looking at?
Looking at my sheets.
Oh.
Over.
I don't see a bond redetermination. I see that he failed to appear the last time on January 5th. And I put 1,010% bond. Then the next thing I have is that he was scheduled for an arraignment on a bench warrant. And it looks like Mr. Flanagan did that. So I don't think there was any bond posted. I don't think there was any bond posted.
I would agree with that, Your Honor. I'm just not certain as to whether or not there's still the tether is still in place.
Well, I can't imagine that he violated and didn't come to court back in January and the tether union didn't notify us to go pick him up like they always do. But go ahead, it could be possible.
So, Your Honor, I would say with regard to Mr. Wallace's past failures to appear, I believe that those have been directly attributable to the fact that Mr. Wallace has been struggling with maintaining shelter. He did come this morning, Your Honor, from the Salvation Army, which I believe also, in addition to shelter, is providing some type of other intervention, which Mr. Wallace probably needs right now. He's here. He's been here all morning. He came in person. So I do understand the prior failures to come to court, but I believe that Mr. Wallace has gotten under that at this point, Your Honor. He knows that the only way he's going to ever be able to stop kind of looking over his shoulder and wondering whether he's going to get picked up and taken to jail or anything like that is by coming to court to bring this matter to its lawful conclusion. That's what Mr. Wallace is doing right now. That's what he's been doing for the last couple of hours since he's been sitting in that courtroom. So I am asking the court to continue bond at this time. I do understand that previously Mr. Wallace did present a risk of flight, and I believe that that's been ameliorated at this point, Your Honor.
Ms. Ritter?
So, Your Honor, seeing that we're still in the pretrial stages, the people are concerned about the flight risk. It looks like there is a lengthy capious history for Mr. Wallace. So if there is a tether, the people are asking the court to keep the tether imposed for Mr. Wallace and no contact order for the complaining witness, Mr. Paul Burks.
Officer Bennett, does he have on a tether?
No, ma'am.
That's a yes or no question. So that's it. So so Mr. Flanagan, tell me, how did the Wayne County Jail know this information that you sent to me?
I spoke with someone, Sheriff Deputy Williams, on Friday, and he indicated that Mr. Wallace was in a treatment facility, and that's why he had missed his court date, and that he would be let out.
I guess I'm asking you, how did they know that? If he's not on a tether, how do they know where he was?
Oh, that, Your Honor, I'm not sure.
Okay. I mean, I don't know how the Wayne County Jail is keeping up with somebody whereabouts who's not in their custody. So if he was in treatment in February, that explains the most recent capious, not the other three, but the most recent one. So we'll go with the most recent one, but his time is gonna always be at something 4. Because if he fails to appear again, the court is going to increase his bond.
Thank you.
All right, anything further?
No, thank you, Your Honor. Thank you.
Nothing on behalf of Mr. Wallace. Thank you very much, Your Honor.
All right, then you're welcome. And we're all set until April 4th at 1:34. Have a great day and stay safe.
Thank you, Your Honor.
You're welcome. I'm ready on Edwards. Matter of fact, maybe we should do Ishmael and McBain first. That's quick, and then I'll do Jeter, Parker, Reed. So let's do it in that order. Ishmael, McBain, Jeter, Parker, Reed. Please start your camera. And please hurry up and start your camera because your picture is not. Can you start your camera, Ms. Ishmael, please?
Yes, okay, there we go.
Okay, ma'am, can you come into camera? You see how we're all sitting in an upright position, ready to attend court? Okay. This is case number 224580901, the people of the state of Michigan versus Quaniel Ishmael. Defendant is charged with 1 count of embezzlement. And today is the date set for pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
And Ryan Marad, P83665, on behalf of Ms. Quiniel Ishmael, who's present on Zoom this morning. Ms. Ishmael, please unmute your device, ma'am, and state your full name for the record, please.
Quaniel Ishmael.
And where? Oh, there we go. Okay. Today is the day set for pretrial conference. How are we proceeding?
Your Honor, we move for dismissal today for the complaining witness's failure to appear.
Ms. Ritter?
Your Honor, it's at least the second scheduling of the pretrial conference, and I don't see a representative on behalf of the corporate complaining witness, Checkers Fast Food Restaurant, present in the waiting room. I don't have any notice that there's someone in person on behalf of Checkers Restaurant in person. So at this time, Your Honor, the people will not be able to proceed based on the complaining witness's failure to appear for at least the second scheduling of the pretrial conference.
Today is the date set for pretrial conference. The complaining witness was required to appear. They have failed to appear. This is at least the second scheduling of the pretrial conference. The people have no explanation for the failure to appear. And therefore, they are unable to proceed. The court is going to grant defense counsel's motion and the matter is dismissed without prejudice. Ms. Ishmael, we will mail you a copy of the order of dismissal for your records. No, you're okay.
Okay, thank you guys so much.
Ms. Marad, why she doing all that? You scared her? You scared her in the breakout room?
I love it, Judge. I'll take it every time.
Ms. Marad, you scared her in the breakout room because what if she's so nervous about saying something?
She's trying to save us all, Judge, make sure we're all on point.
I did that, Judge. I did that.
Oh, that was Miss Stevenson.
That was the mean old lady that scared her.
Miss Ishmael, all you said was thank you, and then you was like, oh.
Because I didn't know if I was supposed to speak right away.
Don't let them trick you. Miss Ishmael, don't believe the rumors and stuff. Miss Ishmael, don't believe the rumors. Okay.
Yeah.
She was so nervous. She was like, oh my God, I spoke out of turn. Okay. All right, Miss Ishmael. No.
Thank you.
You're good. You're welcome. And we will mail you a copy of the order of dismissal for your records, ma'am. You have a great day and stay safe. And I appreciate the reverence that you have for the court and decorum, even though, they scared you in that breakout room, but even though I appreciate it, okay?
Thank you.
You have a great day and stay safe.
You too.
All right, I'm ready on page. This is case number 194647201, the people of the state of Michigan versus Lynette Denise Page. Defendant is charged with 1 count of assault or assault and battery, 1 count of malicious destruction of property. Today is the date set for review. Ms. Stevenson.
Janice Stevenson appearing on behalf of Ms. Lynette Page. Ms. Page, ma'am, please tell the judge your full name.
Yes.
Say your full name, please, Ms. Page.
Denise Page.
Oh, strike that. Okay, today is the day set for review. With respect to Ms. Page, the court does have an update from probation that indicates that Ms. Page was placed on a non-reporting probation for 12 months. She submitted to the one-time urine screen and she was positive for marijuana. She does not have a medical marijuana card. She completed the anger management program and she paid her balance in full. Ms. Stevenson?
Your Honor, Ms. Page did provide me with, she said she gave a copy of the card to probation, but she also emailed me the card just a few minutes ago, Your Honor, which I have forwarded to Madam Clerk. She does have a valid medical marijuana card. It was valid at the time of that test, Your Honor. So I am going to ask the court to dismiss this matter pursuant to MCLA 771.1.
Ms. Stillman, do you have a copy of the card?
Yes, Your Honor, I forwarded it to you.
All right. What is going on? Why is not coming up? Hold on. So, okay. Well, I can't pull it up. I can't pull up my email. I don't know what it keeps. Wait a minute. Maybe I was doing something. Hold on.
Okay.
Oh, I was laying on the thing. Okay. Let's see them. So, she gonna say cannabis card. No, it's the weed. It's a weed card.
That's what they have on your agenda.
I know. It's a weed card. All right. Let me look at it a little closer. Mhm. Well, it wasn't valid at the time. Let me say that.
At the time of the test?
It wasn't valid at the time of the test. The cannabis card was issued effective January 3rd, 2023. She submitted to urinalysis on December the 21st, 2022. It wasn't valid at the time. However, it became valid shortly thereafter. The court will accept it, but it was not valid at the time. It was issued January 31st, 2023.
I stand corrected, Your Honor.
All right. She has passed the halfway mark. The court will grant the request. I will discharge her with improvement and dismiss the matter under 771.1. I don't know what my dog is barking at, but we will mail you a copy of the order of discharge and dismissal for your records. Ma'am, have a great day. Stay safe.
Bye, Miss Page. See you later. I mean, not see you later. I didn't mean that. See you.
Right, because
She like, no, don't see me later.
right.
All right, congratulations.
We've been together since before COVID. So we've been through a pandemic. She had a baby and all kinds of stuff.
Yes.
Well, congratulations. You're welcome. You're so welcome. You have a great day. Stay safe.
All right. Thank you. You too.
All right. Thank you.
Bye.
Bye-bye.